Welcome to the Bar Exam Toolbox podcast. Today we're talking through a criminal law, criminal procedure, and evidence question from the MEE. Your Bar Exam Toolbox hosts are Allison Monahan and Lee Burgess. That's me. We are here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Allison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox Podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. Today we are walking through a criminal law, criminal procedure, and evidence question. This is another in our series of podcasts talking about how to approach questions on the UBE. And don't forget to subscribe to our podcast so you won't miss any upcoming essay discussions. Now, today's question is a particularly helpful one for your bar preparation for two reasons. First, while crossover questions involving more than one MEE subject are not uncommon, it's extremely hard to predict what subjects might be combined. But this question sparked a new trend of combining evidence and criminal procedure, which the NCBE has repeated in recent years. So there's no way to know if that trend will continue for any particular exam, but this is a combination definitely worth practicing. The second benefit is more general. Practicing crossover questions is an excellent use of your study time. It lets you test yourself on two subjects instead of just one. And when you review your answer to a crossover question, you can determine whether you understand the connections between the rules from each of the two subjects. This is valuable as it reveals anywhere that your understanding or application of a rule is unclear or incorrect, allowing you to identify what you need to review or work on. Before we walk through today's question, we need to do a quick review of the law you will want to know for this question. Since this covers both criminal law, procedure, and evidence, we'll need to talk about all of it. So first, let's talk about the evidence part of the question. Hearsay is one of the NCBE's favorite topics to test. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. Whether evidence meets this general definition of hearsay is determined by the parameters laid out in FRE 801. FRE 801A defines a statement as a person's oral assertion, written assertion, or nonverbal conduct if the person intended it as an assertion. Assertions are declarations of fact, capable of being true or false. It's crucial to remember that a statement will qualify as an assertion if it meets this definition. Conduct can only qualify as an assertion if the meaning of the conduct was reasonably clear and if the declarant intended it as an assertion. If the act does not assert or communicate anything, it is not a statement for hearsay purposes. Examples of assertive conduct include nodding to indicate yes in response to a question, pointing at a picture to identify a person, or failing to raise one's hand to indicate no when asked to raise your hand if you wish to respond yes to a question. Examples of non-assertive conduct include involuntary reactions like sweating or laughing, as well as any conduct that does not have a single reasonably clear meaning, allowing us to determine what was being asserted. If the evidence meets the definition of a statement, FRE 801C1 states that an out-of-court statement is one made when the declarant was not testifying at the current trial or hearing. But not all out-of-court statements are hearsay. The final element is whether the statement is being offered to prove the truth of the matter asserted or for some other reason. The truth of the matter asserted is frequently misunderstood. It does not refer to a statement offered into evidence to prove something important to the outcome of the trial, but to a statement offered to prove that the content of the statement itself is true. Put simply, this element rests on whether we are asking the jury to believe that the statement was made and that it was factually true, or only that the statement was made. Now, hearsay statements are generally excluded because they are considered unreliable. The speaker is not present and cannot be cross-examined. giving the judge or jury no way to determine credibility. Rules 801, 803, and 804, however, list a number of exceptions to this general rule. These rules identify statements that meet the definition of hearsay, but will be treated as non-hearsay because they are made under circumstances making them likely to be accurate. For example, a statement made by a party to the litigation is admissible as non-hearsay when it is offered into evidence by the opposing party. Rule 612 permits refreshing a witness's recollection using a document when 1. The witness once had personal knowledge of the matter, and 2. The witness is unable to recall the matter while testifying. Under Rule 803, the document may also be read into evidence as a past recollection recorded if, number 1, the witness had personal knowledge of the events at one time, 2, the writing was made or adopted by the witness, 3, the writing was made while the events were still fresh in the mind of the witness, 4, the writing is accurate, and 5, the witness can no longer remember the event. However, the record may only be received as an exhibit if it is offered by an adverse party. Okay, I know that's a lot to take in, but we also need to review a criminal procedure portion of the question. The Fifth Amendment of the United States Constitution includes a privilege against compelled self-incrimination. When a person is in police custody, law enforcement officers must clearly inform the person of his or her Miranda rights before commencing an interrogation. An individual is in custody if a reasonable person in the individual's position would not feel free to terminate the interrogation and leave. This is an objective determination based on the circumstances of the interrogation, not on the subjective views of the interrogating officers or the suspect. An individual is subject to interrogation not only during express questioning, but when the police know or should know that their words or conduct are likely to elicit an incriminating response. The Fifth Amendment privilege against self-incrimination only protects against statements or conduct that is testimonial. In order to be testimonial, communication must explicitly or implicitly relate to a factual assertion or disclose information. Once a suspect invokes the right to counsel, all questioning must stop until the suspect has spoken with an attorney. However, a custodial interrogation may be reinitiated if, number 1, the suspect is re-advised of his Miranda rights, 2, making a knowing or voluntary waiver, and 3, either A, counsel is present, B, the suspect initiates the communication, or C, at least 14 days have passed since the suspect was released from custody. Okay, now let's move on to reading the bar exam question. This is a question from the July 2016 bar exam. We will link to a webpage where you can find this question in the show notes. A defendant was tried before a jury for a robbery that had occurred at a JoJo Barnes on November 30th. At trial, the prosecutor called the police officer who had investigated the crime. Over defense counsel's objection, the officer testified as follows. Officer: I arrived at the defendant's home on the morning of December 1st, the day after the robbery. He invited me inside, and I asked him, quote, "Did you rob JoJo's bar last night?" End quote. The defendant immediately started crying. I decided to take him to the station. Before we left for the station, I read him Miranda warnings, and he said, quote, "Get me a lawyer," end quote. So I stopped talking to him. Prosecutor: Did the defendant say anything to you at the station? Officer: I think he did, but I don't remember exactly what he said. Immediately after this testimony, the prosecutor showed the officer a handwritten document. The officer identified the document as notes he had made on December 2nd concerning her interaction with the defendant on December 1st. The prosecutor provided a copy of the document to defense counsel. The document, which was dated December 2nd, stated in its entirety, the defendant burst into tears when asked if he had committed the robbery. He then received and invoked Miranda rights. I stopped the interrogation and didn't ask him any more questions. As soon as we arrived at the station, the defendant said, quote, "I want to make a deal. I think I can help you," end quote. I reread Miranda warnings, and this time the defendant waived his rights and said, quote, "I have some information that can really help you with this case," end quote. When I asked him how he could help, the defendant said, quote, "Forget it. I want my lawyer," end quote. When the defendant's lawyer arrived 30 minutes later, the defendant was released. The officer then testifies as follows. Prosecutor: After reviewing your notes, do you remember the events of December 1st? Officer: No, but I do remember making these notes on the day after I spoke with the defendant. At that time, I remembered the conversation clearly, and I was careful to write it down accurately. Over defense counsel's objection, the officer was permitted to read the document to the jury. The prosecutor also asked that the notes be received as an exhibit, and the court granted this request, again over defense counsel's objection. The testimony then continued. Prosecutor: Did you speak to the defendant any time after December 1st? Officer: Following my discovery of additional evidence implicating the defendant in the robbery, I arrested him on December 20th. Again, I read the defendant his Miranda rights. The defendant said he would waive his Miranda rights. I then asked him if he was involved in the robbery of JoJo's Bar, and he said, quote, I was there on November 30th and saw the robbery, but I had nothing to do with it. End quote. Defense counsel objected to the omission of this testimony as well. The court overruled the objection. The defendant's trial for robbery was held in a jurisdiction that has adopted all of the federal rules of evidence. Were the following decisions by the trial court proper? Number 1. Admitting the officer's testimony that the defendant started crying. Explain. Number 2. Permitting the officer to read her handwritten notes to the jury. Explain. Number 3. Admitting the officer's handwritten notes into evidence as an exhibit. Explain. 4. Admitting the officer's testimony recounting the defendant's statement. Quote, I have some information that can really help you with this case. End quote. Explain. 5. Admitting the officer's testimony recounting the defendant's statement. Quote, I was there on November 30th and saw the robbery, but I had nothing to do with it. End quote. Explain. Wow, that is quite a fact pattern. So there is a lot to unpack here. Now, the first thing you should do is mark up your exam paper to assess what is legally significant about each fact in the fact pattern. And we have a lot of facts in this fact pattern. Once you finish reading the question, you need to identify which facts are legally significant and why. We know this question is a crossover involving both evidence issues and criminal procedure issues. We have also read the call of the question, which gives us 5 specific pieces of evidence that were omitted. So we can use those 5 specific questions as a guide. Remember, the facts trigger analysis. So if we list the facts that seem relevant for each piece of evidence, those facts will provide some direction to help us determine what rules are likely being tested. Number 1, admitting the officer's testimony that the defendant started crying. Now let's look at the facts surrounding that testimony. The officer visited defendant's home and the defendant invited the officer inside. The officer asked the defendant if he had committed the robbery. Now these facts trigger a Miranda analysis. The officer questioned the defendant, so we will need to analyze whether the defendant should have received Miranda warnings. When asked if he committed the robbery, the defendant immediately started crying. The officer testified to these facts. Now these facts trigger a hearsay analysis. The officer is testifying about an out-of-court conversation. The defendant did not make a verbal statement, but we know that nonverbal conduct can be a statement for the purposes of hearsay if it was intended as an assertion under Rule 801. Now let's look at number 2, permitting the officer to read her handwritten notes to the jury. The officer testified she could not remember the events at the police station. The prosecutor showed the officer a document which the officer recognized as her own notes detailing the events at the police station. After reading her notes, the officer still did not remember the events, but did remember writing the notes. The officer wrote the notes the day after the events occurred. She remembered the events clearly and was careful to be accurate. The officer was permitted to read the notes to the jury. Defense counsel objected. Now these facts relate to Rule 612, refreshing recollection, and the recorded recollection exception to the hearsay rule under Rule 803. The officer could not remember events, so the prosecutor showed her a document containing the officer's notes of the events in an attempt to refresh the officer's memory. When that attempt failed, the officer was permitted to read the document to the jury. We will need to analyze whether these facts comply with the tests under 612 and 803. Number 3, admitting the officer's handwritten notes into evidence as an exhibit. Over defense counsel's objection, the court granted the prosecutor's request that the notes be received as an exhibit. Now, these facts trigger further analysis of the recorded recollection exception and its limits under Rule 803. The same document has been admitted as an exhibit and read into evidence, so we will need to determine what exactly Rule 803 permits. Number 4, admitting the officer's testimony recounting the defendant's statement, quote, "I have some information that can really help you with this case." Now, after the defendant began crying when asked if he had committed the robbery, the officer advised the defendant of his Miranda rights. The defendant then invoked his right to an attorney. Now, the officer stopped the interrogation, and at the station, the defendant said, quote, "I want to make a deal. I think I can help you." End quote. The officer reread the defendant his Miranda warnings. The defendant waived his rights and said, quote, "I have some information that can really help you with this case." End quote. And the officer testified at trial and recounted the defendant's statements. These facts trigger an analysis of if and when interrogation may resume after a defendant invokes his Fifth Amendment rights. These facts also trigger a hearsay analysis. The officer is testifying about an out-of-court statement made by the defendant. We must determine if the statement meets the definition of hearsay under Rule 801, and if so, whether any exceptions to the hearsay rule apply. Number 5, admitting the officer's testimony recounting the defendant's statement, quote, "I was there on November 30th and saw the robbery, but I had nothing to do with it," end quote. Defendant stated he had information that could help with the case. The officer asked how the defendant could help. The defendant replied, quote, "Forget it. I want my lawyer," end quote. The defendant was released after his lawyer arrived, and then 19 days later, the officer arrested the defendant and read him his Miranda rights. The defendant said he was waiving his Miranda rights. The officer asked if the defendant was involved in the robbery. The defendant said, quote, "I was there on November 30th and saw the robbery, but I had nothing to do with it," end quote. The officer testified at trial and recounted the defendant's statement. Now, these facts trigger another analysis of if and when interrogation may resume after a defendant invokes his Fifth Amendment rights. Now, these facts also trigger a hearsay analysis. The officer is testifying about an out-of-court statement made by the defendant, which will require us to determine if the statement meets the definition of hearsay under Rule 801, and if so, whether any exceptions to the hearsay rule apply. Now, let's look at how to actually answer this question. You would start any outline or answer by breaking your paper into 5 sections, one for each court decision. Note that this question implicates both evidence and criminal law, criminal procedure, so you'll need to consider both subjects as the facts indicate. All right, you ready? Let's do this. The defendant's trial for robbery was held in a jurisdiction that had adopted all the federal rules of evidence. Were the following decisions by the trial court proper? Number 1, admitting the officer's testimony that the defendant started crying. Number 2, permitting the officer to read her handwritten notes to the jury. Number 3, admitting the officer's handwritten notes into evidence as an exhibit. Number 4, admitting the officer's testimony recounting the defendant's statement. "I have some information that can really help you with this case." And number 5, admitting the officer's testimony recounting the defendant's statement, "I was there on November 30th and saw the robbery, but I had nothing to do with it." Okay, so let's look at each one of these decisions separately. Number 1. Was it proper for the court to admit the officer's testimony that the defendant started crying? So this question requires us to discuss both the defendant's Miranda rights and whether crying is hearsay. So our rule is that Miranda protects testimonial or communicative evidence. Testimonial evidence must relate a factual assertion or disclose information. Our analysis is that because crying does not raise a factual assertion or disclose information, it is not testimonial or communicative. Next up, our rule is that Miranda applies only when a suspect is in custody and under interrogation. Custody can be established if a reasonable person under similar circumstances would believe he or she is in custody. Our analysis here is that in this case, the defendant was not in custody at this time. He had just admitted the officer into his home and he was not deprived of his freedom. The officer's testimony the defendant started crying did not violate the defendant's Miranda rights because crying is not testimonial or communicative and because the defendant was not in custody. We also, though, need to mention Rule 801. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in the statement. Our analysis here is the defendant cried but did not make an assertion or communication while doing so. So the testimony about the crying is not hearsay because it was not an assertion. The remaining questions require you to discuss whether the statements are hearsay or opposing party statements. You need to only provide a brief analysis, but it is important to include it. So let's move on to number 2. Was it proper for the court to permit the officer to read her handwritten notes to the jury? Our rule, 803, permits notes to be admitted under the hearsay exception for recorded recollections. A recorded recollection is a record that is on a matter the witness once knew about but cannot now recall well enough to fully testify. The record must have been made when the matter was fresh in the witness's memory. Our analysis here is that the officer once had knowledge of what was in the notes, but because time has passed, would be unable to fully testify. Rule 612 allows witnesses to use writings to refresh recollection for the purpose of testifying. And here, the prosecutor offered the officer her notes to help her recall the events, but that was not enough for her to fully testify. She did, however, testify that she remembered taking the notes and that she was careful to write them correctly. So the conclusion here is that the notes are hearsay, but the court properly permitted the officer to read them as a recorded recollection. The defendant's statements in the notes are not hearsay because they are opposing party statements. Number 3, was it proper for the court to admit the officer's handwritten notes into evidence as an exhibit? Rule 803 provides that written records, if admitted, the record may be read into evidence, but may be received as an exhibit only if offered by an adverse party. Here, the prosecutor used the notes and submitted them as an exhibit. The prosecutor is not an adverse party. The court should not have admitted the handwritten notes into evidence because the prosecutor is not an adverse party. That was easy, right? All right, number 4. Was it proper for the court to admit the officer's testimony recounting the defendant's statement? I have some information that can really help you with this case. Our rule. If a custodial suspect who has invoked his right to counsel initiates post-invocation communication with police, the suspect's subsequent statements may be admissible. The defendant invoked his Miranda rights and then asked for a lawyer. The police properly ceased their interrogation. However, the defendant then initiated further communication with the officer, and the officer provided the defendant with a new Miranda warning, but the defendant then waived their rights. So our rule is opposing party statements are not considered hearsay even when made out of court. So our analysis here is that the statement was made out of court, but it was made by an opposing party. So in conclusion, the omission of the officer's testimony did not violate the defendant's Miranda rights because the defendant initiated the communication with the officer after waiving Miranda rights. Further, because this was an opposing party statement, the testimony is not hearsay. And number 5, we've made it, guys, the last one. Was it proper for the court to admit the officer's testimony recounting the defendant's statement, I was there on November 30th and saw the robbery, but I had nothing to do with it? The rule. If a suspect has been released from interrogative custody, the police obligation to honor an invocation of the Miranda right to counsel terminates after 14 days. Next up is the analysis. The defendant invoked his right to counsel on December 1st, but was rearrested on December 20th. The December 1st invocation was not binding on the officer when the defendant was arrested on December 20th, because more than 14 days had passed. The officer properly provided new Miranda warnings on December 20th, but the defendant waived his rights. The rule is a statement is not hearsay when it is a statement made by an opposing party. So we've already mentioned this rule, so you might note in your answer to just see above. The defendant made this statement and it was submitted by the prosecution, so it is a statement made by an opposing party. So in conclusion, the omission of this statement did not violate the defendant's Miranda rights because he had been released from custody for more than 14 days. Additionally, the statement was not hearsay because it was an opposing party statement. Now, this fact pattern covers a lot of ground, but is an excellent example of how important it is to practice those crossover issues. Crossovers happen with several subjects, but we see them a lot with criminal law and procedure and evidence. Evidence questions are often straightforward, so knowing the rules well is a fantastic way to rack up points in a short amount of time. Also, in a complicated question like this, think about rules that are being used over and over again. You can always say see above for rule and save time by retyping things out. But typically copying and pasting rules over and over again is not a good use of time on the bar because the graders, they don't want to read what you've copied and pasted. So just be easy and say see above for rule and then quickly do your analysis and move on. Well, with that, we're out of time. I want to take a second to remind you to check out our blog at barexamtoolbox.com, which is full of helpful tips to help you prepare and stay sane as you study for the bar exam. You can also find information on our website about our courses, tools, and one-on-one tutoring programs to help support you as you study for the UBE or California bar exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it. And be sure to subscribe so you don't miss anything. If you are still in law school, you might also like to check out our popular Law School Toolbox podcast as well. If you have any questions or comments, please don't hesitate to reach out to myself or Allison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.